Thank you, Mr. Chairman. This markup is about a bill that imposes upon the United States Supreme Court the obligation to promulgate for itself a code of conduct. And it also puts into place some recusal standards for the court and for other judges, other federal judges, and also some reporting requirements. So it's not about Justice Thomas, it's not about peaceful protesters outside of justices' homes where they are peacefully protesting on public property. It's not about that. And it's not about failing to condemn a leak of Justice Alito's draft opinion. We don't know who's responsible for the leak of that draft opinion in the Dobbs case, but we do know that if it was done or directed to be done by a member of the court, including a conservative member, that justice would likely face no consequences. And that's because, unlike every other court in the land, all being bound by a code of conduct, the United States Supreme Court has failed and refused to bind itself to a code of ethics governing the conduct of its members. And that omission is something that we can correct today, ladies and gentlemen, by moving this bill forward out of this committee and onto the House floor. The Supreme Court Ethics, Recusal, and Transparency Act of 2022 would take meaningful steps to ensure that the court polices itself in a transparent and accountable manner. And it would do that by first by requiring the court to draft and issue its own code of conduct for the justices and the court's employees after hearings from experts and the public about what that code should contain. It would also strengthen judicial recusal rules, adding to the number of circumstances in which justices must recuse themselves, and giving parties to cases additional tools to make sure that those recusals actually happen according to the law. Equally important, the bill would strengthen disclosure rules for justices and others. It would require justices to adhere at a minimum to the same level of gift and income disclosures as we members of Congress. What's wrong with that? So that the parties to cases and members of the public and the press can see when justices or their spouses are receiving gifts of travel or exclusive accommodations from parties, lawyers, or those filing friend of court briefs who seek to influence judicial decision-making. It would also help to ensure those friends of the court, amicus curiae, aren't getting too friendly with the justices by requiring disclosure of every person or entity that is paid for the drafting and preparation of friend of court briefs, and whether they have given anything of value to the justices or their families. And this bill, my colleagues, my dear colleagues, is a long time coming. Many of these changes have been put before this body in one form or another for the past decade or more. We're seeing the effects of our inaction now. The word unprecedented is starting to lose its meaning as we see more and more questionable behavior from justices, and the public trust and confidence in the Supreme Court is at an all-time low. By mandating that the Supreme Court develop and adopt a code of ethics, this bill would help restore the court's reputation and reinforce that none of us, not even Supreme Court justices, are above the law. So I urge you all to support this important legislation, and thank you, Mr. Chairman, for your support of this bill, and thank you all to the co-sponsors of it. And with that, I yield back the balance of my time.